All right. Good afternoon, everyone. I'm Mark Pickett. We're thrilled to be presenting this webinar on public defender independence just shortly before the 60th anniversary of Gideon v. Wainwright. This panel is sponsored by the ABA section of Civil Rights and Social Justice and is one of many in a series of rapid response webinars. We are actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on all of these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A and not in the chat function. If you do not see these controls, please ensure your screen is not idle. I will be monitoring the Q&A and we will do our best to address your questions, time permitting. We will be sharing a recording of this program with everyone who is registered so that you can share it widely with your networks. We have a dynamic panel today who will talk to you about the importance of political independence to the public defense function. Our panelists are Robert Berkowitz, who is professor from practice and director of the Defender Initiative at the ACLU University School of Law, and also a former public defender. Derwin Johnson, who is currently the chief legal officer at the Southern Poverty Law Center and is the former chief public defender in New Orleans. Keisha Hudson, who is chief defender for the Defender Association of Philadelphia and also the former chief at the Montgomery County Public Defender, and Charlie Gerstein, who is partner at Gerstein Harrow LLP. And our moderator today is Alex Bunin, who is the chief public defender of Harris County, Texas. And I will pass it along to you, Alex. Thank you.
Thanks, Mark. Again, I'm Alex Bunin. I'm chief public defender here in Harris County, Texas, which is Houston and the surrounding area. Third largest county in the United States. Did not have a public defender before 2010 when I started this office. And the theme today about public defender independence is about really the ability of public defender offices, mostly through their chief defenders, to do policy work, to speak out. We often think about independence for public defenders at the trial level, the individual lawyers, to be free from interference from judges and prosecutors. That's typically Sixth Amendment law. This is more of interference in speech, so it's more about First Amendment law. And I became interested in this. I've been a chief public defender for about 28 years, both in state and federal jurisdictions. And so I've seen a lot of different systems. And in each one of them, they have their own special way of interfering with your work. And it's usually because the people, the administrators, the politicians, the judges have some authority over your funding. And that's what really can stifle your ability to speak out when those folks don't understand that you have certain rights to speak out. And I really discovered this back in 2018 here in Harris County. We have 254 counties in Texas. Each one is controlled by a commissioner's court. That's our legislative executive body. And one morning I read in the Houston Chronicle that they were thinking of getting rid of me because I had done a number of things, they said, but mostly they were upset that we had a federal bail lawsuit going on here in Harris County. They were spending millions of dollars to defend it. And I was apparently aiding the plaintiffs and their lawyers. And so they dragged me in front of Commissioner's Court that Tuesday. But by that point, I had contacted NACDL, our state organization, TCDLA, our local organization, HCCLA, and the Houston Chronicle. So by the time we walked into court Tuesday morning, there were a lot of people there to support me. The Chronicle had run an editorial saying they were foolish to be attacking me and they were on the wrong side of the issue. And by the end of that hearing at which I got to speak, they punted the issue to my board, who later came back with a report and exonerated me, and court never did anything about it. But it could have gone the wrong way. And a lot of times it does. And we're going to talk today about some situations where it didn't go all that well. But this is what got me interested in the whole issue of public defender independence. I've published a couple articles. Holly, can you put up my slide? Or my first slide? Okay. All right. So this is a law review article I did in the Texas Journal of Civil Liberties and Civil Rights. In the orange box, you can see the Westlaw site to it. And we'll put that in the chat later if you don't get it now. And the second slide is a much shorter article that I did in the Criminal Justice magazine for ABA. Also, the Westlaw site's up. We'll put that site in the chat box. But basically, that's a shorter version, a 5-page version of the law review, which was 271 pages with 289 footnotes. So you might want to at least look through the shorter one. But both of them talk about some case studies in which other public defenders beside me were affected. And so I want to get to one of those persons who's here, who's on our panel today, Keisha Hudson, who was in Montgomery County, Pennsylvania at the time when she and Dean Beer were both basically attacked for the same issue I was, but they had to go through litigation. So maybe, Keisha, you could start by talking about that and where you are now and how all that went.
Yes, good afternoon, everyone. Keisha Hudson, Chief Defender here at the Defender Association of Philadelphia. I was in direct representation here, started 20 years ago at the Defender Association of Philadelphia, and then went to the Federal Defender to do capital appellate work for 10 years. And I left that position to join Dean Beer. He was the chief of Montgomery County Public Defender's Office, which shares a border with Philadelphia. And this was in 2016. And I left to join him as the deputy chief because he had a vision for different issues, both internally in building up the practice of the public defender's office, but also quite a lot of reforms that he wanted to prioritize. And it was well known by that point that bail reform was an issue, a significant policy issue in Montgomery County. To kind of broaden out statewide to give folks a little bit of a glimpse into Pennsylvania. We are either the only or one of 2 states where the state does not provide any statewide funding to the public defender agencies. So the public defender agencies are all city, as we are here in Philadelphia, and or county funded. There are 67 counties in Pennsylvania. So very much public defender agencies look different from county to county, depending on their county government structure. In terms of who makes the hiring decisions, it's usually the county commissioners who are elected and can have different policy priorities. As you can imagine, our client population and our work is very rarely on the list of priorities for different political entities. So we knew going in that there would be a challenge to our ability to push certain reforms. We knew we were already under-resourced, we were underfunded, and our ability to gain any traction, particularly on issues of pretrial detention and cash bail, we knew we were going to be limited. And so one of the early moves we made when we started working together in 2016 was to form really strong relationships with the ACLU in Philadelphia. The ACLU is one of actually several organizations outside of Montgomery County, so statewide, and also moved nationwide in working with Gideon's Promise, in working with Participatory Defense, and other social justice and criminal justice reform organizations. And we were very mindful and thoughtful about why we wanted to do that. The infrastructure in Montgomery County, because we were under-resourced, was woefully limited. And we did not have the in-house expertise. At the time, we had a very rudimentary database, so we did not have the data. We really did not have the infrastructure that we needed to understand what the issues were underlying pretrial detention. And so we convinced the county to get a database so that we could stop collecting data by case file. and tracking data by hand, which is what had been happening. And we got a database system, but we also started to train our attorneys on how to interview clients and how to file bail motions and how to argue those bail motions in court. And then worked with community partners and other stakeholders like the ACLU and the University of Pennsylvania to start to track what we were seeing in our pretrial detention. And it was alarming, as it is, around the country. And it was very clear based on what we were seeing in our cases and what we started to collect in our data, was that Montgomery County was incarcerating a high population of people pre-trial on cash bail. 40% of the people in the jails at that time were there just on misdemeanor charges. And 40% of the people who were there on bail that was $500 or less could not afford to pay that bail. And of course, we were seeing a racial impact on that as well. So we very much started to push for ways to reform that system, and we're participating in discussions with the county around a pretrial program. But we were approached by the ACLU, and I have to say we didn't think very much about agreeing to do this because it's an amicus brief, and an amicus brief has never, most of them are not very exciting, right? Most of them are only going to be read by the law clerks if they make their way to a justice. And we had been working with ACLU for a number of years on pretrial issues. And we had some very compelling cases that we wanted to talk about in an amicus brief. So the ACLU of Philadelphia filed this brief. It was against the city of Philadelphia because Philadelphia and all of the county structures were not following the bail statute here, which requires you to make a determination of ability or inability to pay. They were not following that statute in asking the questions to make sure that before you set bail, the person actually has an ability to pay that bail. So that was the basis of the suit. Well, in Montgomery County and all across Pennsylvania, there is no counsel at that bail setting proceeding. There is in Philadelphia, but in Allegheny County, but nowhere else across the state. So public defenders aren't even in the room when bail determinations are being set. So you can imagine what we were seeing happen to our clients was even more egregious. In one case we talked about was a case of a pregnant or a teen mother who had recently given birth, having a bail set of $50,000. It was her first arrest, no prior criminal history, and had just given birth and was expressing milk and incarcerated for 40 days in a county jail with no ability to express her breast milk. And that was one of the cases that we really talked about in the amicus brief to underscore how dire the issue was in Montgomery County. We filed that brief on February 3rd, and almost immediately, we sent a copy of the brief after we had filed to the county commissioners. They had made it very clear that, in certain instances, though they would not interfere with our work, they would want to see, the types of issues that we were raising in the courts. And they had that conversation with the chief defender, Dean Beer. And we filed on February 3rd, and very quickly thereafter, it was clear to us, because the brief had not yet been docketed in the Supreme Court, that the commissioners had shared it with the president judge of the county. And the president judge of the criminal division then proceeded to call Chief Defender Beer and dress him down, for lack of a better phrasing, about the brief, about the content of the brief, about the data that we put in the brief, about the tone of the brief, and wanted very much to understand why he hadn't been consulted before the brief had been filed to give input, and that he wanted the brief withdrawn. There was another follow-up conversation with the president judge where there was a direct threat made to file a disciplinary board complaint against Chief Defender Beer if he did not withdraw the brief and issue an apology to the president judge. February 20th, the commissioners sent a letter to Chief Beer. And what's important throughout this entire conversation, you don't necessarily hear my name yet because I'm the deputy chief, but Chief Beer received a letter on February 20th, and I want to read a couple quotes from this letter because I think it's remarkable in a number of ways in terms of really casting a light on how politics impedes and impacts and tries to circumvent and subvert criminal justice reform and anything approaching client-centered representation. That is not the priority for, that wasn't the priority for the Montgomery County Commissioners, and I would imagine for many of the offices in Pennsylvania. So I'll just read a couple quotes from the commissioners that they were not offered an opportunity for meaningful comment before the brief was filed, that we had not shown good judgment in following the policies of accounting, performance of our duties, and the ability to work collaboratively wherever possible is a goal that we should aspire to. And this last paragraph here that I'll read in full, the ability of the public defender to function independently in the representation of indigent clients in Montgomery County is important. What is also important is the ability of the head of the department to realize the broader implications of acting on certain desired reforms in a manner that is outside the intended scope of the position. Your repeated inability to realize when it is both beneficial and appropriate to engage with the commissioners before taking particular action is deeply concerning. So we got that letter on February 20th, and then on February 26th, early in the morning, and I say that for a reason. It was Chief Beer was fired at around 10 o'clock. I was fired around 10:40 after ignoring their requests to meet in their offices because I had been told Dean had been fired and I wanted to talk to staff and comfort staff. The public defender office is in the courthouse. Most of the county public defender offices are in courthouses. And at 10 o'clock in the morning, you can imagine this was a very busy part of the day. And there are judges and there are police officers and district attorneys and our clients, more importantly, who were in the courthouse, and to be escorted out of the courthouse at that hour of the day through that building in serial fashion, we thought was even more chilling to our staff and to any clients or anyone who we were working with, their family members. And so we thought that was particularly, more chilling. After we were fired on February 26th, the one takeaway that I want folks to be mindful of is the importance of building really good allies in this work, whether they be community allies, faith allies, other organizations, other criminal justice stakeholders, because in the ensuing weeks, they really came out to support the issue and really elevate the issue of public defender independence and draw a very bright spotlight to what had happened and why it was of deep concern. And, we were able to get some national coverage on the issue.
Had somebody come out at the courthouse in favor of you, right?
Yes, and testify, yes. We had 50 people show up to testify at a commissioner hearing, and many of them were from around the country. They were participatory defense members. They were from other public defender offices. They were from the ACLU. They were from faith groups, community groups. And again, that really was work that we had spent 4 years doing in terms of building connections with these groups to help advance policy reform. And it brought the issue of public defender independence in Pennsylvania to a broader platform. I will end with the commissioners were, forced to publicly state that they now understood the importance of public defender independence. Since our termination, they have put together what they term an independent board. Now, what is curious is that there is a rule that the members of that board cannot have recently served in public defense functions, but there are a couple former public defenders on that board. I would say half the board I have faith in choosing the next chief defender, but the mandate of that board is to choose the next chief defender. As deputy chief, I was naive in thinking that I would not also be fired. It was clear to Dean Beer that he served at the pleasure of the commissioners. I was hired by Dean, and it had been made clear to me that he would make any determinations to terminate me. But I think we had been so aligned, not only in bail reform, but we had done projects around exposing racism in the police departments there, and that was a public campaign. But there were a number of issues leading up to the filing of the amicus brief that show that he and I were very much aligned in terms of our policy reform strategies. And so it made sense, I think, in their mind to terminate us both. So that was my experience in Montgomery County.
Yeah, so that's a good segue to bring in Charlie Gerstein, who is your lawyer and can talk.
A wonderful lawyer, Charlie.
Talk a little bit about the litigation, but also just what is special about public defenders in employment law? Because I got a big lesson from you and from others when I had my issues, and I didn't realize that we were a little bit different.
Mm-hmm.
Sure. So I'll try not to bore everyone by going too deep into all of the details, in part because the varying circumstances in which public defender independence problems can turn into litigation problems are just, it would take me too long to explain all of them. But briefly, and the message I want to get across here is you have a lot more, if you're a public defender listening to this, you have a lot more rights than you probably expect relative to job-related retaliation. And we all, I think, want to encourage you to do the things that are going to result in job retaliation, right? The people who employ you, the judges before whom you appear, and surely the prosecutors against whom you try and investigate cases don't want you to succeed at your job. And at least some subset of them don't want you to do your job well. And when you do your job well, with startling regularity, they try to retaliate against you. And one of the reasons I got into this line of work, which I did previously at a nonprofit called Civil Rights Corps and have since taken with me into private practice, is because I thought, the most important way we can change the American criminal system is by forcing more of those unpleasant changes. And that's, obviously what happened with Keisha, right? Keisha was pushing back against an unconstitutional bail system. And the result, predictably, it was that, it pushed back against her. And I hope that you listen to Keisha's story, and Keisha, jump in if you're seeing this differently, but as one with a very happy ending. So we litigated successfully Keisha's case, and now she has a great job and has had a successful and happy professional life. In fact, maybe I would even say this was a blessing in disguise. Would you agree with that, Keisha?
I would agree with that. I will reserve comment on
now that we've settled, we can say that.
Before
we settled, we don't want to say that kind of thing, right? But that your firing was actually good for you, but your firing might have been good for you. And so, listening to Keisha would be like, go out there and get fired. On a practical note, call me before you get fired. Don't call me after you get fired, ideally. Best, in fact, to call me if you're thinking about doing something that is likely to get you fired. Let's plan it all in advance. Standard employment law advice. But so there's a lot of different sources of law that protect defense attorneys and public defenders specifically when they get fired. Foremost, as Alex mentioned, I think in a lot of contexts is the First Amendment. I have successfully so far advocated the view that if you get fired for in-court conduct of a certain kind on behalf of a client that is not otherwise unreasonable, you might have a First Amendment claim. Lots of specifics there, but just keep in mind, if you file, say, a bail motion to try to get your client out of jail because he's being jailed because he can't pay money, which is unconstitutional, and some judge says that's outrageous, calls your boss, and you get fired, give me a call. I'm not going to guarantee that's a First Amendment claim, but often it is. Second category of claim that we see all the time is public defenders doing out-of-court personal political stuff that results in job-related retaliation, bad performance reviews, that kind of thing. I've represented a lot of people in that circumstance. That's a very standard employment law problem that comes up with any public government employee. And nothing about that is specific to being a public defender, except that your advocacy is likely to, I'm trying to avoid swearing here, which I presume we should do because this is going to be published, but it's going to cause problems, much more likely than it would in other circumstances because of the adverse relationships you're necessarily going to have with other people in the criminal system. Again, just zooming out for a second, the nature of the public defender role is that the state is required to provide it, and the state, in some sense, or at least some political entity related to the state, is incarcerating your clients. So there's this inevitable tension between your job and your employment. And when you go out and advocate publicly, you're likely to cause, it's unlikely that you're going to advocate for more jail time right? And more pretrial detention and harsher punishments. Otherwise, you wouldn't really be doing this job. So we get a lot of those outside of court political speech issues. Again, give us a call. Gerstein Harrow LLP. We're on the internet. Someone's going to send around a thing. I also wrote a paper like Alex. You can read it if you have a tremendous amount of time on your hands and nothing better to do, but I wouldn't recommend you do that. Rather, just read the introduction and give me a call. We've recently been dealing with more state tort law cases with fired public defenders, depending on the state. We currently represent Steve Singer, who was fired as Oregon's chief public defender, and we allege that firing was in response for him blowing the whistle on violations of the Sixth Amendment when he said that, the state was doing a poor job, unsurprisingly, in providing for the right to counsel, and that it was wrongful termination because it violated various Oregon public policies. State law in this respect is much more flexible than federal law. So depending on the state you're in, lots of different opportunities there. Again, if you're worried about getting fired, or you've just been fired, or you think you're going to do something where you're going to get fired, just give us a call. This is what we're here for. So a bit of practical advice, I guess, worth doing. Keep receipts. Don't delete your emails. If you're in a state where this is allowed, record personal conversations. I had a client who did that. Excellent. When you've got them on tape threatening you, it's really a lot better than when you just say, he threatened me. And then they say, no, I didn't. And then you pull out the tape and you're like, oh, yes, you did. That's a really great moment. Again, double check whether your state allows that. Don't do it if it doesn't. And yeah, I mean, I could spend a little bit of time talking about why I think this work is important, but I think my fellow panelists are in a much better position to do that. They're the actual defense attorneys and people who represent clients. I represent them. My former boss. Oh, Alex has a question.
Well, so when I went to see my employment lawyer, and she was a great employment lawyer, she, immediately came to her attention was the Supreme Court case of Garcetti versus Ceballos, which basically says government workers don't have speech rights when they're doing their jobs. And that seems to be that we're different. And can you explain why we're different?
Sure. There's a couple of respects in which a public defender, we have advocated the view, I've advocated the view that a public defender representing a client in a case is not a government employee for this purpose, although she's paid by the government because of a case called Polk County versus Dodson. We can get into the weeds here if anybody wants, but at a very high level of generality, that case says that a public defender is not a state actor for purposes of the Sixth Amendment when representing a client. And that means that if she provides substandard service to her client, the client cannot sue her under the Sixth Amendment, cannot sue the entity that employs her for her malpractice. If that's the case, then none of the principles underlying Garcetti could possibly apply here, right? The public defender is supposed to be an agent of the client. We've been successful in making that argument. Separate category of thing that often comes up is that Garcetti protects entities that fire people for ordinary job-related conduct, not anything special or extraordinary. That's a pretty nuanced line, and there hasn't been a ton of Supreme Court case law about it since Garcetti. But in Keisha's case, one point we made, and we relied on the firing of Al Flora in Luzerne County, Pennsylvania, where he succeeded on a similar argument, is that a brief challenging a pervasive practice that has not yet been filed is extraordinary in the sense it's not part of your ordinary day-to-day. There's lots of options here. I don't think in a lot of, and again, don't separately, depending on the state you're in, you probably have a bunch of state law rights, not in Texas, which doesn't, I believe, recognize a wrongful termination tort, but, lots of places do and have a much more protective employment scheme. Same with whistleblowing. And whistleblower laws are usually a lot broader than you would imagine them to be. They protect reports to all kinds of people for all kinds of things, even when you're not ultimately right about the thing you're reporting. And employers have the foolish tendency often to admit that they are firing you for whistleblower violations because they don't know they're not supposed to do that. So I love those ones when they send a letter like, we were tired of you complaining about all of these things because you were wrong, because we were right, and all those complaints were wrong. And even if that's true, that's still whistleblower firing, right? You don't have to be right about the violation you're claiming to be a whistleblower for this purpose. So.
Okay, well, Derwin, as far as I know, you left Orleans Parish voluntarily, but while you were there, I know you had lots of issues and political issues, funding issues, Louisiana generally. Can you talk a little bit about your experiences with seeking independence?
Sure. The difficulty for me was trying to figure out what stories to tell from my time at the public defender's office. And I think, it's important to give a little bit of the history about our office and its sort of genesis. Also want to apologize. I see everyone's in a suit. I actually had a suit on until a tragic lunch accident forced me to put this on. But New Orleans, our jurisdiction is really just culturally split between, if you ever live in New Orleans, folks will talk about pre-Katrina and post-Katrina. There was life pre-Katrina and there's life post-Katrina. And that was true for the public defender's office in New Orleans as well. Pre-Katrina, it was very much a court-centered practice. The chief judge picked the chief public defender. And I had files full of documented employment action that was initiated by chief judges in our criminal court. And I was fascinated by looking at how pliable the chief defender was. I don't want this woman in my court. And then they got rid of the woman in their court. This person is not very good. They got rid of that person in their court, and almost summarily. And so the court was very used to having its way. And it was also something that was under sort of investigation by a lot of advocates, including myself, pre-Katrina. We were trying to figure out, how do we reform public defense in New Orleans? Well, Katrina hit. And when Katrina tore everything up, and it was very clear the public defender's office wasn't capable of standing itself back up, it gave us an opportunity. And so we had in place a chief judge at the time who was sympathetic, forced the existing local board. The chief judge appoints a local board, which then appoints the chief defender. That chief judge got the existing local board to all resign, and a reform board was appointed. That reform board began to initiate reforms to create a client-centered office. I was part of that first reform local board to create the office. And though that sparked fierce fights in the court, lots of contempt that we were fighting around the courts for various and sundry things. My favorite is when a judge told one of our lawyers, if you touch that book, I will hold you in contempt. That book that she was going to touch was the Louisiana Code of Criminal Procedure. He did not want her reading from it to him. And so that was our environment when we were trying to reform the office. So post-Katrina, when we're reforming this office, we're running into a lot of different problems. And we pass at the state level the Public Defender Reform Act of 2007. And what that does is it kills all the local boards, gets rid of local judicial control, and creates a state board that then selects public defenders for each judicial district. And the board has diverse appointing authorities. They're a little less diverse now after some backlash, but still, it was a way to get a more independent public defender office. Still, our jurisdiction did not go without a fight. And ironically, that same mechanism for independence also provided tension when we started actually acting independently as a public defender office. And so there were a number of moments as the office matured that we saw ourselves in a client-centered lens as people who were responding to community needs, client needs, people who were now willing to talk about injustices as we saw them in our judicial system. All of our lawyers, for example, were required to read and were given a copy of Ordinary Injustice. It's part of the lawyer training in our office. And it's so that you understand and are able to notice the temperature of the water you're in, so that it doesn't seem like the everyday. And we began acting like we noticed the temperature of the water, and that bugged some people. And so we had different moments where folks were trying to inhibit our ability to advocate on behalf of our clients and advocate for reform. We had a moment in 2009. Post-Katrina, we also started advocating for funding, as Alex hinted at. We began a very deliberate and intentional campaign to increase our funding. We were woefully underfunded. We live in a user-paid criminal legal system here in Louisiana, and wanted to have more parity with other agencies in our criminal legal system. And so we started to advocate for funding, and our city council, who had never funded us before, and also had no mandate to fund us. There was no statutory requirement to fund us. We were asking for funding from our city council. Now, that same city council funded our district attorney in 2009, it was about $7 million or so. They gave us zero. And so when they gave us zero, I said they were jeopardizing the public safety of New Orleans, to which the budget chair took exception. So I was on a radio show where the budget chair called in, tried to berate me about misleading the public. And I said, here's why I'm not misleading the public. Here's what public defense does. This is who we are. And she had no knowledge of the criminal legal system. So it was really, it wasn't a fair fight on the radio, and she got embarrassed. So she called another city council member who's a friend of mine to have him talk to me about what I'm saying in the public. And I told him that, we go to these budget meetings, we're incredibly gracious, despite the fact we are treated horribly. And he responded to me by saying, "Who are you to be gracious?" is what he said. And that produced some choice expletives from me, and then some back and forth. And I told him, I said, we are not powerless, and I can show you better than I can tell you. And he's like, "What do you mean?" I said, "I meant exactly what I said. We are not powerless, and I can show you better than I can tell you." And we again began to criticize them for their moves. And then the next year we got funding, and we've received funding ever since. And before I left, we were able to pass a parity ordinance so that whatever funding they give the DA, they have to give us 85%, or public defenders 85% of the same. There was another moment where in the battle for reform, one of the judges basically told a deputy to essentially attack one of our staff, to arrest one of our staff. And I responded in the media that they needed to have a judicial investigation of that judge. He took exception to that because he knows, like I know, that they can actually spark investigations based on news reports. And he knew, and I knew, that the Judicial Council was a friend of mine, so that he did not really like that. That resulted in the entire criminal court bench voting en banc to file a disciplinary complaint against me. Because judicial investigations are supposed to be private. So that was the basis of their complaint. It went nowhere. And most recently, we had in our reform, our sort of latest set of advocacy and influence on our system, had a number of public defenders run for judge. And one of our board members, who was a family lawyer for one of the judges who was being challenged by one of our lawyers, was calling for our resignations, saying we were campaigning on the clock, which we were very scrupulous not to, but also DAs do it all the time. And we had assistant DAs running for judge who were also, quote unquote, on the clock. That also went nowhere. And I think the point in all of this is to understand that we are not powerless and that we can build constituency and have these debates in criminal legal system reform. We can influence our systems. We can advocate on behalf of our clients if we have the plans before we do it, and we have, quite honestly, the courage to take those steps in spite of some pretty stiff and sometimes very powerful opposition to what we want to do.
Great. Bob, you're an academic, you've been a public defender, you go around the country consulting on litigation involving public defenders. What's your view?
Well, thanks, Alex, and thanks for inviting me. And it's just a kick to be involved with this group of really outstanding advocates, and I'm pleased to be part of it. When I first became chief defender in Seattle at what we call the Defender Association as well, Keisha, in Seattle, in another century, there were federal dollars for training for new chiefs. And I went to a training in Portland, Oregon, led by, among others, Marshall Hartman of blessed memory. We spent a good half day talking about how to deal with interference from judges and political leaders. As it turned out, in my nonprofit office with a board of directors that was chosen actually pretty independently, including the Bar Association, I rarely experienced that kind of interference. A handful of times a judge would contact me about a particular lawyer. One time a judge complained to me that I was not hiring from local schools, that I had an Ivy League bias. I was able to show him that we hired more lawyers from the 2 local schools than from any others, although we did have about 30 different schools on the staff. He also complained that I had not hired a lawyer that he recommended. I explained to him that person had never applied to the office. I was able to be active for systemic reform, both in Washington and nationally. And I think in some way, the more I did that, the stronger our position became. Derwin has really talked about his own personal clout in New Orleans. And I think the more you can develop relationships with the community and the bar and the press, the stronger you are in a situation like Alex described happened to him. I did have interference from the local Office of Public Defense, which was the county administrative office that we contracted with, because they played off the nonprofit offices against each other. When I started, there were 2 offices. When I left, there were 4. This, of course, helped with conflicts of interest, but it also allowed the county to let one office underbid another for parts of the contract until we had developed and accepted standards that limited that approach. Sometimes individual judges would participate in the county's effort, and sometimes my office lost some business to one of the other offices that underbid us or played the game the way a particular judge liked. We also were punished for challenging the city's practice of sending clients to a jail in another county. But because we had established a strong independent status, we were able to sue the county on jail conditions. And when the case settled, the county executive called my deputy up to the press conference podium to say, "I'm counting on you to hold us accountable." So that was a strong moment about the power, as Derwin put it, that you can develop as a defender office. I've been to places around the country where, just like Derwin described, the chief judge picks the chief defender and thinks that's how it should be done and doesn't like to be challenged about it. I was driving around one state with a chief defender who was in a state office chosen by the governor, when the governor's office called him as we were driving to say that they wanted him to hire a particular person. Of course, when judges or governors control who gets to do public defense, they can either directly influence the practice or by intimidation and implied threats, they can both determine who is hired and what kind of job they do, often to the detriment of clients. We all have heard stories of chief defenders fired because they asked for more funding or parity with the prosecutor. In our state recently, we had one judge telling the local public defense administrator how to do her job. We had one chief defender fired after she made public disclosure requests about the prosecutor's charging policies to support a claim that she was making of racial disparity. We had another chief fired when the local county commissioner election shifted the power balance, and he had pushed for funding for adding social workers, and that contributed to his ouster. One chief defender was threatened because she opposed building a new jail, but because she had a strong advisory council and a county charter provision that required the chief defender to advocate for social justice, she survived the threat. What we have done in our State Bar Council on Public Defense is to propose an amendment to our existing bar standards for defenders and to propose a new court rule on independence to the state Supreme Court. Both approaches, standards and court rules, have led to great positive change in our state. Strong connections to the community, to the bar, and support from the media can make a huge difference. Allie, could you start with my slides, please? This is an article that I wrote, much shorter than the 200 pages of Alex and Charlie. It's available on my website as well as the State Bar. And I talk a little bit in there about both some of the examples I mentioned and the standards. Next slide, please. So one of the things we've done in the Council on Public Defense in Washington is to ask the Supreme Court to get involved. And the Supreme Court has actually asked us sometimes to propose rules and standards. And this rule that was just put into effect this month is on defender independence. And the Supreme Court seeks to prevent conflicts of interest that may arise if judges control the selection of public defense administrators or the attorneys who provide public defense, the management and oversight, and the assignment of attorneys in individual cases. Next slide. So here's the rule. You can find it. It's on courts.wa.gov. And basically, the purpose is to keep judges out of selecting public defenders, managing it, and assigning in individual cases. Now, we do have exceptions. If for some reason the normal process doesn't make a lawyer available, the judge can appoint somebody. But basically, it's supposed to happen by an administrator. And if there is none, it should be on a rotating basis from an independently established list of assigned counsel. And then if for some reason there's nobody available, then the attorney has to be appointed who meets the qualifications under our standards, which are part of a court rule. There is in the commentary, okay, if you can't, it's still okay for you to offer your opinion to evaluation and so forth, but you can't control who gets the job. Next. So this is the first of two standards that I want to mention, that we have, these public defender standards. And this talks about a diverse working force, but it also says that judges, judicial staff, city attorneys, county prosecutors, and law enforcement shall not select the attorneys who are included in a public defense contract or an assigned counsel system. So the judges cannot be picking who's going to be getting the cases. Next. So these are, this is the cover sheet for the standards. I should have put it in the front. And then standard 19, this is the new one, that public defense providers should not be restrained from independently advocating for resources and reforms necessary to provide defense-related services. You can all read this for yourselves, but basically it has the court rule language in it again about judges not interfering and picking, and that attorneys should be insulated from judicial and political influence. Next. And what we put in here was, okay, particularly smaller jurisdictions, and we have a lot of small counties and small cities that have courts and have to hire public defense services. If they can't have an administrator, they should consult with somebody who knows what they're doing. So for example, I happen to be what's called the assessor for public defense services for a small city that only has 2 public defenders in their courtroom usually. And they hire me to oversee what's going on and now to pick who's on the conflict panel because the judge can't do that. I want to just mention to wrap up that there's a lot of ways to, you can stop the slides, a lot of ways to build power, as Derwin put it, in advance of having a problem. And when you have a problem, to work with existing national and state organizations, whether it's the ACLU, like Keisha was saying, NAPD, NACDL, NLADA, other organizations, and to build your own state and local organizations. And, you know, one of the first things that happened to me when I took over was the budget was cut 10%. And I ended up going to the press and getting good op-eds and editorial support. I ended up being able to raise money from local companies where lawyers that I had known in the practice were now working as general counsel for these companies. So developing the support in the community is so critical, both to defending yourself in situations, but also in advocating for reform. And I really do think that the more chief defenders are active in pushing for reform and working with the community, the stronger they're going to be when they're challenged. Thank you, Alex.
Great, thank you, Bob. We do not have a federal public defender on our panel today, but I'm a former federal public defender, and I just wanted to mention a little bit about how that system differs. There are 2 kinds of federal public defenders. There's community defenders, which are nonprofits, and they're federal public defenders that are federal employees appointed by the various circuits. And I've been both. And I can tell you neither is completely independent. If you're a community defender and you're an executive director of a nonprofit, your board is picked by the district court. So they can hire and fire you. If you're a federal public defender, you are appointed by the circuit, and that's supposed to give some distance from the districts. But in fact, the districts do have a lot of input. And when I had finished my 2nd term, I was a federal public defender for the Northern District of New York and the District of Vermont. And I think I was finishing my 2nd term, and I'd managed to upset both chief judges. One was mad because I was in a federal capital case and he really didn't care for some of the pleadings I'd filed. And the other chief judge was mad because I wouldn't hire a lawyer that he really wanted me to hire. And I just didn't want to do it. So luckily my circuit executive kind of smoothed things over and I got another term, but that's how the politics can play even when you don't have politicians involved. These are just judges. And the entire federal system is overseen by committees of judges who, you know, back when I was doing it and the money was, you know, coming in and we were just a small part of the budget, they didn't care. But then came what was known as the sequester, in which, you know, the entire federal government was cutting and the judges wanted to keep their part of it and we were going to get squeezed. So federal public defenders have long been known as the gold standard, but they're not completely independent either. And, you know, I think the point I would be making is public defender independence is aspirational until we can print our own money. You know, funding is always going to be an issue and people who control the funding will always have some power over us. But I want to talk to you about just throw some questions out to the panel about some ideas that have been promoted as independence ideas. And one people talk about from time to time and exists in some places in the United States are electing public defenders. How do you folks feel about that? Anybody want to take a shot?
I feel like I'm the only person who's going to even tentatively advocate that this is a good idea. So if anybody else wants to join me on that, I'll wait about 10 seconds and then I'll make my case.
Well, I don't know if I'm ready to advocate for it, but I will say this, and that is there are some aspects of the elected public defender that are helpful and actually sort of validate a lot of what has been said already. If you run a campaign and you have to be elected, it means if you're doing it well, you have to work to build constituency and relationships. And so you are, in fact, at some level, growing a sort of constituent. You're growing a constituency. You're growing your community, so that for the sort of fights ahead, you will go in on somewhat equal footing with a lot of other decision makers who are very often elected officials. The other sort of pro on that is elected officials treat other elected officials differently. And so they look at you as an equal and generally aren't going to say, who are you to be gracious, for example, because they would fear your constituency having been a successfully elected person in the system. The cons to that, I think, and I've seen some of these in different jurisdictions, is that to get elected, you don't depend on an affinity constituency. What I mean is you don't depend on your community, the folks you serve and the folks who you care about through your work. You have to, because generally speaking, that community is not enough to get you elected on its own. So you have to appeal to the center or the right, or you have to appeal to other constituencies to get the votes. And so I've seen things like victims hotlines for public defenders' offices as they campaign. I've seen issues where chief defenders in elected jurisdictions shy away from criminal legal system reform, or even some thorny cases. They'll fight to not represent people. And with that, I can't abide. And so those are some of the sort of ups and downs when you talk about elected public defenders.
I just want to chime in here really quickly to say that until, and maybe it's a utopia, until the narrative about our clients and who our clients are changes, I would be very concerned about having an elected public defender and who would be able to garner enough support and then on the other hand, accountability. And in Pennsylvania, Philadelphia right now, we're dealing with an increased gun violence, but I'm particularly concerned about how the average person talks about our clients, most of whom are young, and stopping just short of using the word super predator. So that's the era that we are in right now in terms of how people are looking at our clients and our youth who are predominantly Black and brown. And my concern would be this would invite someone who does not have the priorities for our clients in mind to run, and the people who would be voting, right, would have to, again, as Derwin said, would have to cater to the center or to the right. And then as a chief public defender here, I want to be accountable to the people who I work with. And I think as an elected official, there is an issue around that accountability and that transparency. And I want the people who work as public defenders here, regardless of whatever role they work in, to feel that I can be held accountable and not to a 4-year term or, knowing that I'm going to be reelected. And for that period of time, I'm in some sense untouchable and have no accountability to defenders and to clients.
I'll just say 2 quick words, and then I'm curious to hear what Charlie has to say. I think it depends a lot on where you are. I think if you're in Miami or San Francisco, it's different than you're in Tennessee. I think there's been some really great defenders in Tennessee and some not so great defenders in Tennessee. And I think it really depends a lot on the locality that you're in. Is it a university town? Is it not a university town? Certainly a lot of what Carlos and before him, Bennett, we're able to do in Miami, some of it's extraordinary, and there's a lot of community networking you can see on their webpage, like Derwin was describing in New Orleans. Same thing in San Francisco. But I share Keisha's concern. One of the things that I didn't like the nonprofits being taken away in King County that happened, but one of the things I did was to work with the county council staff on developing charter amendments that would preserve a measure of independence for the chief and have a term of years that was equal to the elected prosecutor. So during the term of years, of course, if the person's doing a lousy job, the concern Keisha has of accountability is raised, but it does protect against interference during that term of years.
Yeah, I think oddly, I don't disagree with anyone so far. And just at a high level, I think I could summarize as saying the idea is as strong or as weak as the democracy that supports it. And generally speaking, we all supposedly favor popular sovereignty over important political decisions. And I think how we defend people accused of crimes and facing incarceration is an important political question, right? I think it odd to describe something like public defense as non-political. And so once we have decided that this is how we want to control a political system, and obviously we elect prosecutors in all, local prosecutors in all, but I believe one state, which is New Jersey, again, you get the good with the bad. Like, obviously there are very bad results in there. I can tell, as I'm sure all of you can better than I, horror stories of elected public defenders kowtowing to donations from police unions and et cetera. But that's something I would be unhappy with for any elected official. I'd be unhappy when the DA does that. And, we appear to have contented ourselves to that as a society. And so, my high-minded political rhetoric in some sense just like depends on understanding a functioning criminal legal system and a functioning democracy, which I might well be just falsely assuming. In fact, I obviously am falsely assuming in some ways. But if we do make those assumptions, then I would rather a public defender who has to answer to the people that he or she serves than who is in some sense viewed as a technocrat, like he has some magical expertise that the public couldn't possibly understand. But I don't view the defense function that way, right? I mean, and I don't think community defenders view it that way. Community in that, not the federal community defender sense, but actual defenders who view their role as in relationship to a political community don't see themselves as technicians or as some ways magical wizards who can whisper to the legal system and that's it, but they're accountable to the communities they serve. And you can make that literally true by electing them, again, through a non-gerrymandered community, right? So if you're like in a county with a very large suburban population and then a city, if you're elected by the large suburban population to represent people primarily arrested in the city, like you have an obvious political mismatch in terms of whom you're answering to. But that is a problem for electing any office, right? And I don't think in that respect, public defenders ought to be viewed as some special kind of thing. I think the same is true of judges, by the way, right? This idea that judging is some, grand omnipresence in the sky, whispering mysterious thing that's non-politicalized struck me as odd. And historically, like the response to the Jacksonian attempt to start electing judges and prosecutors in some ways involved exactly these kinds of debates. They were like, well, they'll become captive to the people they're supposed to be regulating. And obviously they have, right? So in some ways, it's not a very optimistic portrayal, but, I'm not categorically opposed, I suppose. I wonder why anyone would care what my view on the subject is, but here 173 of you are listening. So I certainly appreciate it.
So, my view about any of these ways of trying to get independence is a lot of it is local, that there is no one size fits all. So to that extent, I'm okay with elections where elections work. So when the late Jeff Adachi used to have rallies to come down to City Hall in San Francisco and stop people from cutting his budget, I mean, yeah, he should. That's a great place to have an elected PD. But I think we all remember the guy in Florida that ran because he had such a great relationship with the police and then later had to be removed from office because of misconduct. I mean, it really depends on where you are, whether that's going to work or not. So I'm not completely against it, but I wouldn't want it here. And, our friends in Tennessee used to have to change parties just to run. which seems it's not disingenuous, but it's like, why should they have to do that?
Well, it is a little disingenuous, but and it's a mutual friend we're talking about. But I think that's in essence the answer for me is that is a way to achieve independence, but it is not a silver bullet for our system. It's not a silver bullet for our country, where you have these jurisdictions where the public defender is going to be free to campaign on the principles of the Sixth Amendment and have that matter in the election. I think it works. Where they have to pretend the Sixth Amendment doesn't exist, I think that is a danger to our profession, and more than that, a danger to the citizens who have to walk into those offices and be represented by those people. And so it's not the answer, but it may be an answer in places like San Francisco or Miami.
Well, as I've already articulated, I don't think there's a one size, but do any of you think there is a model that we should be aspiring to?
No.
I don't know. One of the things that I've done a lot of work with the Sixth Amendment Center, which takes the position that there's no inherently one better way, and that the folks in the locality, whether it's a state or a county or a city, really need to make that decision informed by other examples. And so a lot of the times in the reports that we did, we would talk about other places as possible models from which to draw. I like the nonprofit a lot because it did give me more independence than I think I might have had in some other situations. But every year there was a threat that we weren't going to be funded anymore, and there was this constant battle for many years where the county was encouraging other nonprofits to bid against us. By developing standards, we were able to contain that a lot and minimize it over time. But one of the things that struck me is, in a lot of the things we're talking about, is some sort of advisory board. And if there's an advisory board that has some power, that is truly independently chosen and that has community representatives on it, ideally some former clients or their families, as well as bar leaders, then I think the advisory board can provide some protection, whether it's an elected person or an appointed person or a nonprofit.
Yeah, I think it's pretty universal that everyone thinks the board model is very helpful. That certainly helped me when I was being attacked. And that was before, now at that time we had commissioners and judges on my board. We've now revised it so it's completely independent of judge. There are no judges are on the board, but they have no voting power. So they're part of it, but they don't decide. And I think that's the best model. But in my, when I wrote the article, I looked at places where the hiring committee sometimes has the sheriff. And there was a couple of places in California like that. I mean, that's incredible. So maybe just talk a bit. Yeah, there's no one model. What practices besides the board do all of you think should be implemented that would help?
Briefly, just because it sounds so similar to what we're talking about now. So my firm currently represents Steve Singer, and who was recently fired as chief public defender for the state of Oregon. And the way their board is set up is that it's an ostensibly independent board. The statute requires that at least one member be a formerly incarcerated person who was previously represented by a public defender in the state, that a certain number of people have a public defense background, that none of them have a prosecutorial background. It has all sort of checks all the boxes. The chief justice of the state is a non-voting member. and she appoints the members of the commission. When she wanted to fire Steve, she had an easy way to do that. She went to the commission, said, please fire Steve. They refused to fire Steve. So she fired all of them and then appointed them with people who would fire Steve. And then they did. I think on one level, you might think, well, that is a total failure of how the system is supposed to work. And I think it is. I do. This is not how I would have designed this. If you're going to have a board, you have to at least give them some kind of protection, maybe something like for cause protection. But I'm no expert on this kind of thing, but it sounds as though the Chief Justice took a significant political hit for having done this. So at least there's some cost extracted by this. But, you know, independence from the judiciary is probably, I think, among the most important views here, like making it so that the judges are not the people who choose this. Because I think other than prosecutors, and it's actually not clear who would be worse here, they're among the worst people to be making this decision, because as any experienced attorney knows, it is not always good to make a judge happy. Like the judge isn't your client, and the judge doesn't always rule for you when she's happy. She sometimes rules for you when you're right. Crazy notion. But yeah, avoiding that seems like the point that I would try to make.
Well, I would only slightly disagree, because I don't think that was a failure in Oregon. That went down exactly how the rules are written for it to go down. She was given that's when, and that's
well, just to interrupt for one moment, I do not concede, this is being recorded, I do neither believe nor concede that this was consistent with Oregon law, because it wasn't. It constitutes management by the Chief Justice, which is forbidden by Oregon law. I think it is maybe how the Chief Justice would have imagined it succeeding, obviously, but.
Well, and to that point, I think it was a violation of law, but I think the rules were written in violation of the law that gave her the inkling that she could do something like this. But to me, it means the distance from the judiciary is of primary importance, and you need good rules, good laws that keep that steady and in place. And together with a diverse board with multiple appointing authorities, with independent members on that board. I had a moment where a former chair of our state board basically came to get me. And so there was a bunch of evaluations that didn't go their way. And there was this final meeting where I'm in this meeting with my board chair and other members of the state board. And the board chair said in that meeting, if I didn't have a board, we wouldn't be having this meeting. I would have simply fired you, is what he said. And I was like, in that moment, I'm like, man, I'm really glad we got this board thing, because you got to get enough votes to get rid of me, and you just didn't have the votes, and so I think that can be a bulwark, well written, well maintained, because there's always a level of diligence to all this. I often joke in change management that the empire always strikes back. But when the things are rightfully in place, you get to exert sort of autonomy in your role, and you don't have to particularly worry about what's going to happen to you professionally or economically in some cases with some of these actions.
We'll say Philadelphia, we have been around since 1934 and started off as a very small group of passionate community defenders. And now, we've grown to almost 500. We do have a board that, has assured me all manner of autonomy, but we are entirely funded by the city. And so last year, when the city of Philadelphia, when the mayor did not give us any increase in our budget, we had to decide how aggressive and proactive we would be in challenging the city's lack of funding and the mayor's lack of funding, and balance that with then relationships with city council members who could, support that funding, and we were ultimately successful, but it was not comfortable. So though I enjoy my autonomy, and it's quite a different picture than Montgomery County, and I feel secure in my role, the fact remains that we are funded by the city, and I have to tread a fine line, because the city and the mayor can decide to flat fund, no fund, cut funding based on advocacy or what I am saying or doing in that advocacy or in the press.
I want to emphasize one word that Keisha said earlier, which is alliances. I think it's just critical to build alliances all across, other defender offices, former defenders in the private bar, former prosecutors, former judges, leaders in the community, reporters, editors, just and then with national and state organizations. It's just having those alliances can help you in your reform advocacy, help you attract good people to your office because you're respected, and help you defend yourself when you're in trouble. So I think that's a word that I really want to emphasize.
Yeah, I think you alluded to it, but we didn't talk much about it. Media, having media folks that know you. I mean, when I got in trouble, one of the editors at the Chronicle called me and said, "We're going to have a board meeting. Would you come?" And I did, and that was the basis for their editorial supporting me. So, being known as credible and trustworthy in the media will help you later when you need them.
And part of that can be writing op-eds yourself or getting other people to sign op-eds that you write. And as I mentioned, one of the first things I did when I became chief was to go to the Seattle Times. And I think over time, I was able to develop that kind of support and credibility that also enhanced when you're respected in the media, then the bar looks at you too. And so I think all of that, whether you're defending yourself or you're advocating for something, having a multi-pronged approach of media, bar association, community is just critical.
I second or third that. Within, I think, an hour after we were fired, the Philadelphia Inquirer had an article up, and that was because my second call after I called my husband was to a reporter at the Inquirer who we had a long relationship with and had written some articles for us on a variety of issues. And so for that to be picked up immediately, I think was critical for us in our case in bringing light to the issue. I will say also never underestimate the power of being on background. And of course, we always have to prioritize our client and our client confidences, and it has to be strategic, but on policy issues, particularly if you have data or narratives that you can share without violating attorney-client privilege, you can always, with a trusted reporter, explore the boundaries, but you can always be on background, and we should be more proactive in at least educating journalists about the work we do, because they often get it wrong.
One idea I've heard more about recently is the idea of a defender general as an edge. Okay, then Bob, you talk about that. You defend that.
Well, I really like the idea of a defender general that would, and of course, it doesn't make sense if you already have a state public defender, but and Vermont, I think, has a defender general, but having a state officer that can.
Hey, Bob, I was talking about nationally.
Oh, nationally, I think would also be fantastic. Okay. I mean, back in the 70s, we were talking about having a national defender center, which in a sense, the director of that would almost be maybe not on par with the attorney general, but I think it's a great idea to have a central place that has the respect and like Derwin was saying, is at the table with other people that have power. That's one of the advantages of an elected public defender. And I suppose it can, depending on the state public defender, if there is such a position, is at the cabinet level with the Attorney General of the state. And so if you don't have that, having someone who is the Defender General, either for the state or the country, if we, I know Steve Hanlon is really optimistic about getting more federal funding for public defense. If part of that were to have a center for public defense that gave out grants and established national standards and had a really robust training, that would be fantastic.
I'm a little more cynical of the Defender General myself. But I think the positives, as Bob articulates them, I think that's real. They're cabinet level, seeing eye to eye with other peers in the criminal legal system. It connotes an importance and respect, but the devil's always in the details. So what are they? It'd be fun for me to stand next to Biden and call myself the Defender General and like go to like parties and stuff. But if I'm not really impacting anything, what's the use? What's going to be my sort of portfolio role and responsibility in that role, right? And to that point, for me, one thing I'd love to see, and I think would actually, in a real way, impact independence at the state level, which is where, let's face it, all the magic happens anyway, is if there was an enabling statute for DOJ to sue for state Sixth Amendment violations. If they were enabled to actually enforce the Sixth Amendment across the country, I think you would magically see states doing better in how they structure and fund public defense. And you'd see a lot less gaslighting to just straight up disrespect if that were the case at the federal level.
Well, and systemic litigation is something we haven't even mentioned until now. And, I think both here in Washington and New York, where I was involved with Harrell Herring, I think the systemic litigation transformed New York State public defense and is still doing that. And so I know that a lot of people are skeptical about systemic litigation, but I think it's a tool in the that we ought to have. And also litigating about caseloads is something that, even though it can be sometimes not so great, but often it can make a difference. And so I think having litigation as part of the overall approach to advancing public defense makes a lot of sense.
Yeah, I agree with that. You have to have friends that are willing to sue you, because it's not something you as especially if you're a government person like I am, I really can't just take on my county and sue them. So you have to have other folks. But the bandwidth on that is not huge. Charlie used to be at Civil Rights Corps. They do a little bit of that work. ACLU is a state-to-state thing. You have some criminal legal nonprofits that are interested in that work, but unless you're in the right place, nobody's going to answer your call. So it's tough. So that would be a great use of a Defender General if they could take on that responsibility, because otherwise it's just a bully pulpit. Go ahead.
Yeah. And a serious problem that is that you can bring these cases only in state court, with the very rare exception, and that would obviously be something changed by a federal statute modeled on something like Section 14141, where you have sort of a pattern practice case against local public defense providers. Dream on in terms of getting it passed, I'm afraid, but it's certainly a fine idea.
Well, and sometimes we had a case out here that made a big difference. It was brought in state court, and the defending cities removed it to federal court. And I think they thought they were in good shape because the federal judge was a former prosecutor, but it turned out that he had been a prosecutor against our office, and he knew what quality public defense was supposed to be. And he ruled for the plaintiffs in a tremendous case. It's called Wilbur versus Mount Vernon. And the Justice Department came in with a statement of interest, just like they did in Harrell Herring. Two cases are really tied together in a lot of ways. So sometimes the defending government will help you out and go to a federal court that gives you a good result.
So we got a lot of Q&As, but most of them are comments. So I'm having a hard time like pulling them all out, but there was a recent one that asked if PDs can get burn grants. Answer is technically yes. And I think Congress tried to make it easier, but if you're here in Texas, good luck. It has to go through the governor's office. We almost got one and then they yanked it back at the last minute. So yeah.
We have access to those funds here in Philadelphia, but it takes, again, it goes through various entities, including through the city, through the police department, and may not come as a surprise that we are not at the top of the list for disbursement. So we get the grant funding, it's supposed to come to us. It's a lot of bureaucracy before it makes its way to us.
One of the earlier questions was, what do you do about defenders that are basically being compliant? You know, they're just, I guess like that guy in Florida that got elected to help the police, but I don't know what you do about it.
Well, I think part of what has to happen, particularly in smaller jurisdictions, is to empower the person who's running public defense and give them support. And, you know, Derwin talked about courage, and part of it is that. And it's easier to be courageous in Seattle than it is in Mississippi. But I think building support in the community and the local bar with other defenders banding together, if there is no state association, there ought to be one, so that defenders can go to each other for support, get the kind of NACDL help that Alex was talking about. Because, you know, I had a former student who, when I was at the Defender, he was an intern, and he became chief defender in a small county. And he told me at a conference, Bob, I can't do the things you want me to do because I lose my job and I want to stay in that small town. And so I think trying to help out people that are in that situation, brainstorming how to resolve that. And, you know, we're trying to do that in NAPD with a mentoring program. And I think there's a lot of folks who can offer that kind of assistance.
Another thing we didn't talk about are state commissions. We have a commission here in Texas. I'm on the commission because they have to put a public defender on it. Governor doesn't know me from Adam, but I'm the member, and you know, we hand out money to counties, and we've created a lot of these regional public defender offices. You know, Texas has 254 counties, so that you have these tiny counties that barely have lawyers, and if you bind them together, then they might have enough money to have a PD's office across several counties. And we've funded some of those. And if you put, you know, we hand out the money with stipulations, like you got to have caseload standards, you got to do this, you got to do that. So even if they don't want to do all those things, they really want the money. And they're willing to say, okay, we'll do that if you give us money, because we got to pay for lawyers somehow. And it seems like the public defender office is the best way. So that's one way of like increasing our footprint, and to the extent we increase our footprint, we help each other.
And Texas is a really good example of where reform has made a difference, both in your office in Harris County and statewide with the commission. When I first started working with the ABA, we would sit around talking about how can we make a difference in Texas? And it has been transformed over time.
Mark, did you see any other questions that I've missed that we should be putting out there?
I can promote one. We're kind of at the end here, but there's this might be a good one to end it on. Can every panelist just say one thing that governments can do to fix this issue of lack of independence?
Well, I'll start. The first thing is to cure the funding and, you know, too many cases. Once you get rid of those two issues, and we know how to fix that, that's money and caseload restrictions, then you can get on to protecting defenders on all these other issues that they need to be at the forefront.
get educated on this concept called the presumption of innocence and what it means to advocate. I'm not bringing up zealous advocacy, which is the goal we're all trying to reach across the country here. But I think the understanding of the importance of our role and the constitutional impact of our role and requirement of our role and who our clients are, I think until politicians understand that, we're always, I think, going to be under prioritized.
I think governments can be standards based in their approach to public defense. That'll mitigate a lot of what we're talking about with folks who may not have courage. If they can be like, well, this is the standard, they can just stick to the standard, and that's, if it's a good one, that is really helpful. And I'll take a little privilege and also say, work to reform. Be curious about reforming the system. We need to also shrink it. It's the criminal legal system is behemoth now. It is engulfing families and communities, and in ways that are simply not helpful, and manufacturing problems in our neighborhoods and communities. That's one thing governments can do, is stop expecting the same different results from doing the same bad things.
I would just add diversion, reducing the system, because we can put way more money into it, but as long as we still have too many cases, we're going to have problems. So all the things everybody else said, and emphasize diversion and reclassification.
Okay, Mark, you want to close this
Yeah,
out?
I will close this out. Thank you, everyone, for joining us today for this free webinar. And of course, I'd like to thank our panelists for taking the time today to take part in this. They brought a lot of expertise and just an incredible amount of relevant experience to this discussion. The ABA section on civil rights and social justice provides a number of free webinars and resources for legal professionals and advocates nationwide. So we hope that this panel helped you in your work. And again, if you are interested in joining the ABA and becoming an active member, please do so. You can find more information at americanbar.org/CRSJ. And if you're interested in learning more about the ABA's work on public defense matters, you can just go to indigentdefense.org, and that will take you straight to our public defense page. There's also a newsletter that I put my email address about in the chat. Thank you again to everyone else for joining us, and have a great rest of the week.